Hello and welcome to Prescriber Insights, navigating FDA updates on semaglutide and tirzepatide for clinicians. Today we're going to be discussing the most up-to-date status of tirzepatide and semaglutide prescribing and compounding, and we hope to provide an understanding of what this means for prescribers and the business models that they've developed during the course of the shortage. I am Arielle Miliambro. I'm a partner in Frier Levitt's regulatory group. I focus on professional board regulations, such as those pertaining to prescribing and dispensing, scope of practice, fee splitting, and at a broader level, I work in matters related to digital health, fraud, waste, and abuse, and privacy and security. I am joined by my colleague, Martha Rumore, who, in addition to being a pharmacist, is senior counsel with our firm and has a deep subject matter knowledge and experience in both FDA and intellectual property issues, both of which are critical to today's discussion. We are with Frier Levitt, which is a healthcare and life sciences law firm, and our team of 50+ attorneys assist stakeholders across both of these industries in various regulatory, transactional, and litigation-focused matters. In terms of quick housekeeping, just keep in mind that we are lawyers, but we're not giving legal advice today. We're going to talk about these issues generally and at a high level. I'd encourage anyone who's interested in discussing these matters further to reach out, and we're happy to continue the conversation. Our contact information will be listed at the end of the presentation. So to jump right in, for the past several years, while GLP-1 products have been on shortage, there have been two primary business models through which prescribers have been ordering and patients have been receiving these medications. Namely, a prescriber could order the drug from a 503B outsourcing facility, and the outsourcing facility would deliver that stock to the provider's office. This has enabled practices to maintain their own inventory and dispense or administer medications to patients directly. Alternatively, prescribers could issue a patient-specific prescription and deliver the same to a 503A compounding pharmacy. And that pharmacy would then prepare and dispense the medication to a patient. There are nuances and regulatory considerations in each of these models, and with FDA's announcements related to tirzepatide and semaglutide coming off shortage, the practicality and legality of each of these models will be impacted. As an initial matter, and as Martha will discuss at length in a bit, a 503B facility will no longer be able to compound tirzepatide or semaglutide after the end of the respective grace periods for these drugs. So come March 19th for tirzepatide and May 22nd for semaglutide, a prescriber won't be able to procure additional inventory of these products from a 503B outsourcing facility. So this is going to leave prescribers with essentially two options. They can issue a patient-specific prescription and send it to a 503A pharmacy for fulfillment, or they can develop an in-office sterile compounding operation, purchase bulk ingredients in the same manner that a compounding pharmacy would, and then they could compound patient-specific prescriptions for their patients themselves. There's technically a third option, which is to leverage 340B savings and dispense the brand product in the context of these models. But because of 340B eligibility considerations, we're not going to focus on that today. We're just going to focus on compounding. So with respect to the two options that we are discussing, it's imperative that any patient-specific prescription not be an essential copy of a commercially available approved drug once the grace period ends. There are very specific requirements as to how a formula has to be altered, so it won't be considered an essential copy, and Martha will get into that in much more depth shortly. But ultimately, it must not be identical or nearly identical to the FDA-approved drug, and the change that's made to the compound to make it so it's not identical has to produce a clinical difference for a specific patient. With respect to this latter requirement, the prescriber will be responsible for making the determination of the clinical difference, and it's recommended that the prescriber identify their rationale on the actual prescription order. So examples might include none of a particular dye, patient allergy, or liquid form, patient can't swallow a tablet. Assuming that the compound is issued and is not an essential copy, either by the compounding pharmacy or an in-practice sterile compounding operation, they can each conceivably compound that product, whether now or after the shortage ends. And with respect to creating a sterile compounding operation in a practice's office, I want to emphasize that it's not a small undertaking. The practice may need to comply with USP 797 and 800, which are regulatory standards that govern compounding and the handling of medications to ensure patient and provider safety. So USP 797 focuses on sterile compounding, setting guidelines for sterility and preventing contamination. And USP 800 addresses the safe handling of hazardous drugs to minimize exposure risks for healthcare workers, patients, and the environment. So prescribers who are compounding or dispensing medications in office should be aware of both of these USP standards and make sure that to the extent that they apply, that they are maintaining compliance with those requirements. Setting aside the compounding itself, I want to switch gears and discuss just the larger business arrangements that can exist in these two models, and the limitations associated with them and their regulatory considerations. So first and foremost, many of the GLP-1 focused models are not structured such that patients are receiving in-office administration of these products. The drug is being dispensed, whether it's from the physician or from the pharmacy, and then the patient self-administers the product, perhaps after self-administering in the office for the first dose, to enable clinical staff to train them on how to do so. In a 503A pharmacy model, we've seen instances where the pharmacy ships directly to the patient, which is preferred from a compliance perspective. And we've also seen instances where the pharmacy ships to the physician practice, and then the practice accepts it as the patient's agent. The practice is then the one that ultimately hands off the product to the patient. It's really important to distinguish here that the prescriber is not dispensing the product when it's been fulfilled by a 503A pharmacy. The pharmacy has dispensed the product, and the prescriber has accepted possession on behalf of the patient. To the extent that a prescriber is indicating that they have dispensed it, or if they're altering the product in any way, that can be considered unlicensed practice of pharmacy. We have seen a number of models that do not make it clear to the patient or anyone else that the product is being fulfilled by a pharmacy. And we've also seen arrangements where prescribers are getting a larger supply on behalf of a patient and then only providing a limited amount of that product to the patient at one time. So if a prescriber is ordering a 90-day supply from a 503A pharmacy, accepting possession on behalf of the patient, but then taking that 90-day supply and only doling out 30 days at a time to the prescriber, to the patient, this can create liability for the prescriber. Depending also on how the drug is packaged, if the prescriber is pre-filling syringes, this could be considered compounding or unlicensed practice. So even if the prescriber is not engaged in an activity like this, if there is an adverse patient reaction and the product has been in the possession of the prescriber for an extended period of time, there's a good chance that the pharmacy will try to point to the prescriber as the source of the issue with the product because they've been storing it. And the pharmacy may claim that the prescriber's storage is what affected the stability or otherwise caused an issue with the product. Separately, it's important to just be aware that there are certain states that won't permit a prescriber to act as an agent of the patient for purposes of receiving a dispensed prescription. So prescribers just need to be aware of the regulatory frameworks for these models in the jurisdictions where they're operating. In a practitioner dispensing model, there's also limitations imposed by state boards of pharmacy as to when, what, and how much of a drug a prescriber can dispense pursuant to their medical license. While some states only allow a prescriber to dispense an immediate supply of a product to enable the patient time to get the rest of their order fulfilled by a pharmacy, other states will allow for 3 days or 7 days, or there won't be a limitation. In either event, it's critical for prescribers who are engaged in practitioner dispensing, which can offer greater financial flexibility to do that. They need to make sure that they're dispensing in accordance with state laws in the states that they're dispensing. And with that, this can also be impacted by whether the prescriber is engaging with a patient via telehealth. When a prescriber does have a primarily telehealth model, dispensing can be even further limited because the prescriber may not be able to mail the product or offer it to a patient who's not available to pick it up from the prescriber's office directly. So the dispensing model is feasible in some states more than others based on dispensing limitations, but also based on other limitations that may be associated with how much a prescriber can mark up a product that they're selling. For example, New Jersey Board of Medical Examiners prohibits practitioners from charging more than their cost plus 10% when they're dispensing a drug to a patient. Turning to the financial relationships between a prescriber and a pharmacy, the most common model we've seen in the GLP-1 space is one where there is a single payment by the patient, and then this is divided between the prescriber and the pharmacy. And if it's telehealth based, then with the telehealth company as well. Many people believe that where they don't accept insurance for a particular service or product, that they don't have to consider kickback rules, but this is inaccurate. There are several states that have any payer kickback prohibitions, meaning that kickbacks are prohibited irrespective of who pays for the product, even if it's provided on a cash basis to a patient. So some of these any payer kickback rules are imposed by licensing boards. So liability will really fall on the prescriber more so than a telehealth company. But in others, there are criminal penalties associated with the kickback prohibitions, and those tend to apply to all the parties in the relationship, not just the licensee. And the Florida patient brokering prohibitions are a good example of this. The way that these rules can get triggered by a lot of the single pay or all-in subscription type models, where a prescriber is obtaining payment from a patient and then passing a portion of that to the pharmacy for the drug being dispensed. If the amount that the pharmacy is getting is not consistent with fair market value, then it could be viewed as a discount to the prescriber in exchange for the referral. And then that discount enables the prescriber to keep a larger portion of the subscription fee. In a model where a prescriber and the pharmacy are each charging the patient directly and they don't have a financial tie to each other, this is not as much of an issue. But this concept of creating a kickback through the discount and enabling a prescriber to retain more of a patient's payment can also lead to potential self-referral violations based on state rules where a prescriber has a financial relationship with the pharmacy that they're sending their scripts to. Fee splitting rules are state specific and typically prohibit a licensee from sharing or dividing their professional fees with a non-licensee or someone who didn't contribute to rendering professional services. It's somewhat similar to a kickback, but it doesn't require quid pro quo. So there doesn't need to be a referral in exchange for the payment. It's just a payment being made to someone who's not involved in the professional service. This is another regulatory consideration that stakeholders, particularly the licensed stakeholders, need to be aware of, because most of these rules are in the context of licensing boards and unprofessional conduct. States also vary widely on how they address fee splitting. New Jersey, for example, doesn't have a broad fee splitting prohibition separate from potential implications on corporate practice of medicine that come along with sharing professional fees. But New York, on the other hand, does have a very broad fee splitting prohibition. On the whole, from a state perspective, parties need to ask whether there are state kickback rules, fee splitting, self-referral that are going to apply to their model. And then if there are, what needs to be done to ensure the model stays above board and what safe harbors or exceptions are relevant. Generally speaking, in most states, there is a mechanism to accomplish the goal of offering that patient a single payment service that includes professional services and pharmacy fulfillment, but the parties just need to be aware of how the rules are going to inform and need to inform the overall structure of the relationship. Another topic we want to quickly touch on is the overall involvement of a telehealth or telehealth company or telehealth services in many of the GLP-1 models. So whether you're currently using telehealth or you want to be using telehealth, you need to be cognizant of the state requirements in terms of what modalities can be used to create bona fide practitioner-patient relationships, and what's necessary to prescribe via telehealth. Some states allow asynchronous encounters, store and forward encounters. Others are going to require two-way audio-video conferencing. We're also starting to see, especially with respect to asynchronous encounters, more and more states impose requirements that the provider obtain the patient history from a health information exchange or another practitioner who's actually treated the patient. So that's something to keep in mind if you are doing exclusively asynchronous encounters. Many states also have limitations on prescribing via telehealth if the ordering is done exclusively based on an online questionnaire without any other type of interaction or information from the patient. So the modality ultimately that gets used is informed by state law where the patient's located, but the standard of care also comes into play, as do payer requirements if there's any reimbursement being sought. We are actually seeing some GLP-1 prescribers remit claims for payment for their service and then charge the patient on a cash basis for the drug. If that's something your practice is doing, this can create issues with payer contracts and also just invite greater scrutiny by virtue of having the payer evaluating the provision of care. So that's something to absolutely keep in mind in the context of these relationships. And also the involvement of a telehealth company or platform also raises issues with respect to the fee splitting and kickback concerns that I just mentioned. So we've seen a lot of telehealth models surrounding many drug products, not just GLP-1s, but that they purport to have prescribers and pharmacies ready to go. And then a marketing arm can kind of just come plug in, drive patients to a web address, and then hand those patients off to get a script and then receive the drug by mail. Most of the time, these plug-in models present themselves in a way that appears to allow the marketing arm to keep a cut of the business that's generated by the rest of the parties in the model, specifically the physician and the pharmacy. This is a dynamic that really needs to be carefully scrutinized, and diligence needs to be performed by both parties in the arrangement or both sides so that the marketer is not exposing themselves to liability from a kickback perspective, and that the licensees are aware of how marketers are linking in and generating patients for them. So the financials need to be structured and transmitted carefully between the parties to avoid unnecessary risk. The last 2 points I want to discuss quickly before handing this off to Martha are, number one, despite all of the FDA considerations, it's important to recognize that a prescriber who's not compounding, assuming that they're not compounding, is not the one that's primarily responsible for ensuring that preparation of these GLP-1 products adhere to FDA rules. Even if a prescriber were to write for an identical essential copy of a commercially available drug, it's the compounding pharmacy that's responsible for identifying that issue and then either dispensing the brand or notifying the prescriber that an essential copy can't be compounded. Obviously, this changes a bit where the prescriber is the one compounding, but in instances where they're not, it just puts things into perspective a bit in terms of liability on the prescriber side. And the final thing that I want to mention is we've already seen Legit Scripts start reaching out to its accreditation customers with the message that's on the slide right now. So it's really important to not just respond promptly to avoid consequences of losing the accreditation, but a lot of models really require a deep dive into how they're structured and what they're doing to make sure that they are compliant and that they are tailoring their website and marketing appropriately, both during and after these shortages and the grace period of these shortages end. And with that, I'll hand things off to my colleague Martha, who'll get much more granular on the FDA related nuances and the updates that you are eager to hear with FDA's recent announcements and relevant litigation.
Thank you so much, Arielle. And I just want to say that both Arielle and I are extensively involved in 503A, 503B physician practice space, particularly for the GLP-1 compounded products. And it does keep us quite busy these days. So this slide is an overview of what I'm going to discuss with my time with you today. I'm going to look at the current rules of engagement for 503A and 503B. And for 503A, we're not just referring to compounding pharmacies, but we're also referring to physicians who compound as well. Your 503B compounders, they're also known as outsourcing facilities. Those are the larger scale compounders. Then we're going to look at the OFA, the Outsourcing Facilities Association versus FDA, Eli Lilly. There's two cases there, one for tirzepatide, one for semaglutide, and those cases are pivotal to GLP-1 compounding. And finally, I want to touch briefly on a case that involves an investigational GLP-1 that's soon to be FDA approved, and why FDA is now being sued and by Eli Lilly. It's on the opposite side. And so this case also has implications for GLP-1 compounding. Next slide, please. So FDA's purpose is to protect patients. Compounded drugs, as you know, they are, not FDA approved, meaning that the FDA doesn't really verify their safety, effectiveness, or quality before they're dispensed. The FDA's additional purpose, as you see on this slide, is preserving access to compounded drugs for patients who have a medical need for them. And that medical need, clinical difference, is something we're going to spend some time on today. There also is a 506E FDA shortage list, which pertains to tirzepatide and semaglutide. Both of those drugs are now off of the 506E shortage list, and they're in what's known as resolve status. All of this falls under the 2013 Drug Quality and Security Act, the DQSA, and the implementation of that. And pursuant to that act, FDA has issued something like 24 draft or final guidance documents, and that's an awful lot in a particular area. FDA is also involved with memorandum of understanding, and they've twice tried to promulgate these memorandum of understanding, which would do such things as require pharmacies to report the adverse drug reactions, or there would be some distribution limits for compounded drugs. And so the reason I bring this up now at this point is that most recently FDA has stated that they're going to be updating the MOU, and they're going to be attempting once again to try to have the states sign on to it. And this time they've alleged that they're going to go through the proper rulemaking process so that it can't be challenged. So this has implications for pharmacies having to report adverse drug reactions, as well as the quantity of compounded products that can be distributed interstate. Advertising rules, FDA is involved with that. FDA initially had prohibited all advertising of compounded drugs, but that certainly isn't the case today. But there are some strict rules to follow for advertising of compounded drugs. FDA does conduct inspections of 503A pharmacies. That's usually together with the state boards of pharmacy. And they've conducted over 500 inspections. They've observed problematic conditions in most of those inspections. They've had something like 150 recalls of compounded drugs. They've issued warning letters, and there's been, other activity. They also have this Pharmacy Compounding Advisory Committee, a PCAC, and that committee advises the FDA on bulk substances nominated for use in compounding. So there's this bulk substance list, and there's been a nomination of these GLP-1s for that bulk substance list. And that list basically would say that they can be compounded whether or not they're on the shortage list. There's some rules for it, but that's something that FDA has not acted on the nominations to put these GLPs on the bulks list. Conversely, there's what's known as a difficult to compound list, and you have the manufacturers having filed petitions to put both of these GLPs, semaglutide and tirzepatide, on the difficult to compound list. And once that would occur, then they couldn't be compounded under any circumstances. And again, the FDA has not acted on those petitions to date, but just know that those things are in the background. We also have, there's another thing going on. You have the brand company pressures, there's actions, there's litigation. So this is the landscape, if you will, for compounding and for the GLP-1s. Next slide, please. So where do physician practices obtain GLPs for patients? Arielle mentioned this, touched on this. We have option 1 is from the 503B facilities. That's office use that need not be patient specific. We have option 2 from 503A compounding pharmacies that must be patient specific. Some of the 503A pharmacies compound themselves. Others have been purchasing from 503B outsourcing facilities. So option 3 is if the physicians are compounding themselves. And as Arielle mentioned, that's quite an onerous test because they do have to adhere to USP 795, 797 if they're compounding sterile products, such as the injectable forms of these GLPs. The rule is, and here's the rules, once off the FDA 506E shortage list and the grace period ends, option 1 will no longer exist. So the 503B supply is going to be drying up. And the reason for that is that they can only compound drugs which are either listed on the FDA 506E shortage list, and there's a 60-day grace period, or they're listed on the FDA 503B bulks list, which right now neither of them are. The 503B facilities can compound in bulk or pursuant to a patient-specific prescription if they are also registered as a pharmacy. So some of your 503Bs, it gets a little complicated here, are also 503As. But once it's off the FDA 506E shortage list, only the 503A portion is able to compound, and that's under circumstances that are on the next slide. So this is the rules of engagement. This is right out of the FDA guidelines, and this pertains to 503A compounders. There are 2 terms on this chart that are important to understand for 503A compounding. One is essentially a copy, and the other one is clinical difference. So while a drug is on the FDA 506E shortage list, essentially a copy of the commercially available drug can be compounded. And that's because if it's on the shortage list, FDA doesn't consider the drug to be commercially available. So, for example, while semaglutide was on the shortage list, 503A compounders were able to compound and physicians were able to prescribe the commercially available dosage strengths of, for example, 0.25 milligram per 0.05 ml, or 1 milligram per ml, or 2.4 milligram per ml, and it was not considered essentially a copy. But now that it's off the shortage list, then they need to look at the analysis of what is essentially a copy. And that's the second box on this flow chart. To be essentially a copy, it has to be the same API, active pharmaceutical ingredient. It has to be the same or easily substitutable dosage strength, and it has to be the same route of administration. If the answer is no to any of those 3, then it's not essentially a copy and it can be compounded under Section 503A. If the answer is yes to those 3 questions, then you go to the next box, which says, was a change made for an identifiable individual patient that produces a significant difference for that patient? So if so, then it's not essentially a copy and it can be compounded. Next slide, please. So this just is another way of showing the same thing on the flow chart, the essentially a copy. So it has to have the same API, same similar or easy substituted dosage strength, and it can be used by the same route of administration. The thing I mentioned about the dosage strength is it's plus or minus 10% of what's commercially available. So that's like a calculation that the pharmacies need to do to figure out what's not essentially a copy. Adding a second ingredient may make it not essentially a copy, but only if that additional ingredient is not added at the exact strength as the commercially available product. So for example, the addition of pyridoxine, 4 milligram per 0.05 ml, is a strength that's not commercially available. Pyridoxine is available at 50 and 100 milligrams. And so if you're adding 4 milligrams per 0.05 ml, then you're adding something that's not commercially available, and that makes the whole compound not essentially a copy. The same thing with, others are adding L-carnitine, ondansetron, glycine, methylcobalamin, B12. So if the prescriber provides an indication of why these additional ingredients are needed, then that goes to medical necessity. Can I have the next slide, please? So this is just another, way of showing if it's a sublingual form, then it's not the same dosage form. Then it makes it not essentially a copy. Then, oral is, again, it's not essentially a copy. Dosage strength, route. And the FDA has said no specific format is required for the clinical difference to be shown. They're not going to judge physicians' determinations. Once a physician says that this particular difference is needed for their patient, and it has to be explicit, then the FDA is not going to be second guessing the rationale that physicians provide. Can I have the next slide, please? So this is just an example of the clinical difference. We have gastrointestinal tolerance statements. For example, patient experiences nausea with commercial product, requires addition of B6 to lessen nausea to continue therapy. Patient unable to tolerate commercial product due to GI side effects. Modified dosing schedule statements, such as the patient requires microdosing 3 times weekly due to severe GI intolerance. Multi-dose vial with B6 is needed, and then there's a reason there. If you look at modified route statements, so for the sublingual form, might be something like patient has difficulty swallowing tablets or maneuvering injections, or patient has had a adverse reaction at the injection site from the injection. Something like that would be a clinical difference or a rationale. Excipient sensitivity statements, patient can't tolerate the commercial product, or if they had an adverse reaction to the commercially available product. Combination need statements, so it's things like add B6 to lessen glucose fluctuations and or hypoglycemia, add B6 to decrease nausea and vomiting, add glycine for muscle wasting, add B6 to alleviate nausea to promote adherence to the treatment plan. Any of these are going to be clinical differences. And what we see is that many pharmacies are going to have these on order forms for physicians to check off. And this is important because there has to be a clinical difference for an individual patient. And this will allow there to be a break in patients going in different directions for different reasons as to why they need to have the compounded version rather than the commercially available product. The only thing I would say to physicians is to make sure that your clinical patient notes reflect the reasons that are on the prescription, because at some point we don't know what's going to happen, and I'm going to talk about risks on the next slide, but it's important that it's documented in the patient's record that they had nausea, they did indeed have nausea, and that's why you're switching to a compound that includes B6 to alleviate the nausea. Next slide, please. So risks to physicians, as Arielle mentioned, the risks are mostly to pharmacies. We've had board of pharmacies very few boards of medicine, and there's very few court cases with regard to essentially a copy. There's only one case that we're really aware of. It's Hope Medical versus Fagron Compounding. And then in that case, the California Central District Court evaluated whether compounding sodium thiosulfate without potassium was permissible under the Food, Drug, Cosmetic Act, or if it was impermissible because the pharmacy was compounding essentially a copy. The real issue in that case was that the pharmacy was using generic statements such as compounded product is medically necessary for the patient. Those kinds of blanket statements, which you see on the slide here, vague or blanket rationale where the pharmacy fails to clarify. So for example, patient prefers compounded version vials to pens, or the compounded product is medically necessary for the patient, or the patient has a hypersensitivity to the commercial product. Those are too broad, and they don't specify what the problem is, because what's the hypersensitivity? Is it the phenol in the product? Is it, so it needs to be a little bit more specific. If it's not clear, the pharmacy is going to have to call you to obtain clarification as to what the clinical difference or the medical necessity is. So it's important that it be specific, right from the get-go. As far as the risk to physicians, we haven't seen this really, but that's not to say we might not see it in the future. Possibility of unprofessional conduct. And how does that occur? Well, the patient's been taking essentially a copy previously, and they've been taking it for so long. There's nothing documented in the chart that says they had nausea or anything like that. And then suddenly they need a formulation. Once it goes off the FDA 506E shortage list, grace period, and everything else, they need a formulation with a clinical difference for every previous patient. So that is an inherent risk. There's really no getting around that. One thing we advise is to make sure you've documented everything. Some physicians are placing a diagnosis code on the prescription, but not the diagnosis for weight loss or anything like that. The diagnosis for nausea, the diagnosis for muscle wasting, those kinds of things. We also want to mention aggressive manufacturer actions. And if you are, advertising these products, you want to make sure that you're not using any of the brand trademarks or you're making any safety and efficacy claims, especially if you're using the clinical trial data from the brand products in your promotion, of these GLP-1s. All of the lawsuits basically against pharmacies, 503A compounders, they've all alleged that the trademark was used. So you see statements like similar to, and the brand name, I don't even want to say it, similar to the brand name, generic version of the brand name. And those kinds of things, that's just evidentiary of trademark infringement. So that's something to keep in mind. The most common enforcement risk scenarios to date that we see is where a pharmacy case is opened, for one reason or another at a board of pharmacy. Maybe they didn't have a license in that state to ship. Arielle spoke about the telehealth, telepharmacy thing. Maybe they don't have a license, or maybe some other issue, and then the case is also opened with a board of medicine or a board of nursing. And once that occurs, then it just opens up a whole cascade of questions from these boards. Like a board of nursing may ask, in states where the nurse practitioners don't have independent prescribing authority, they may ask for a copy of the collaborative practice agreement and stuff like that. Another common enforcement scenario we see is if the patient is harmed, if there's some kind of FDA MedWatch report from another healthcare professional, for example, an ER doctor or something like that, then that MedWatch report is going to get the FDA involved, and then the FDA often refers it to the boards of medicine, the board of nursing. So that's something that also is a common enforcement risk scenario that we see. Next slide, please. So this is a case I just want to talk about a little bit. This is the Outsourcing Facilities Association versus the FDA. And this case pertains to, this was a motion for preliminary injunction that was filed by the OFA. It was denied on March 5th, 2025. And the result is that the FDA's decision to declare the tirzepatide shortage over officially remains in place. And so because of that, the 503B outsourcing facilities are no longer going to be able to compound tirzepatide in 2 days, March 19th, 2025, while the 503A compounding pharmacies are prohibited from compounding essentially a copy immediately. So right after March 5th, they couldn't, except for these reasons that we spoke about for the not essentially a copy and the medical necessity. So not essentially a copy in and of itself is a reason that 503A can compound, but we are recommending that they follow a belt and suspenders approach where they take not only the not essentially a copy, where the dosage is plus or minus plus 10%, but also then they have documentation of clinical difference. So there's two things going on there. We do expect the manufacturer, in this case for the tirzepatide, to act aggressively with more rounds of cease and desist letters. And also with regard to this case, the preliminary injunction motion, as I mentioned, was denied, but the OFA is appealing. So it remains to be seen what's going to happen there. Next slide, please. So this case pertains to the February 21st, 2025 semaglutide removal from the FDA 506E shortage list. And so there is an off-ramp period. The off-ramp period for 503As is April 22nd, 2025, or until the district court's decision on the plaintiff's preliminary injunction motion, whichever is later. And for the 503B outsourcing facilities, they gave them 90 days to cease until May 22nd, 2025, or the preliminary injunction decision, whichever is later. The thing that's a little unique here about the semaglutide that we haven't seen before is that the FDA, in their clarification on their website, they're using the words compounding, dispensing, and distributing. Previously, for the tirzepatide, you see that they said they had to cease compounding by these dates. Now they've added dispensing and distributing, and dispensing is clearly outside of the purview of FDA. Distributing could be, wholesaler, but 503Bs cannot wholesale anyway. So, it's just a little bit of a gray area when the 503B sells to a 503A, and then is the 503A permitted to still dispense that product after the grace period ends if it was compounded before the grace period. So we're preparing an opinion piece about that. And please reach out to Arielle and I if you are interested in receiving that. These cases are coming about because this OFA and some of these compounding pharmacies, they're saying that the FDA's removal of these products from the 506E list was premature. And just today, I heard from several directors of pharmacies at hospitals that they just can't get the brand product, the commercially available drug, and that it still is indeed on shortage. And it is on shortage in the American Society for Health System shortage list, so it's still on there. The question is, how did FDA resolve the shortage, and did they take into consideration the demand for the compound that from these compounding pharmacies? There's all these pharmacies and that have been compounding. How were they able to figure that out if that's not a reportable piece of data from anywhere? So that's one of the issues in these lawsuits. Next slide, please. So I just want to talk about this case because it has implications for the future of GLP compounding. It pertains to the drug that's currently in phase 3, the GLP in phase 3, the retatrutide. And that drug is soon to be FDA approved. Once it gets FDA approved, it's going to be, the same as the other GLP-1s. It's probably going to go right on that shortage list. Right now, for example, you still have liraglutide, which is a GLP that's on the shortage list. So there's, once they get approved, they go right on the shortage list. The issue here is that the manufacturer is trying to immunize the drug from compounded copies. And it's alleging that the FDA exceeded its authority, violated its own regulations, and abused its discretion when it refused to put the drug into the category of a biologic product over the manufacturer's objections. So if it's less than 40 amino acids, it's a peptide. If it's 40 or more amino acids, if it's 41 amino acids, it's a biologic. Why is this significant is that if it's a biologic, it can't be compounded. And so the issue is hinging here on an amino acid, where Eli Lilly says the branched amino acid is still should be counted as an amino acid, and FDA says no, it has to be an alpha amino acid. So that's what this case is all about. If Eli Lilly is successful, then you can expect all future GLPs to follow suit, and that's going to be an issue. Next slide, please. So mitigation for 503As, I mean, the one thing I want to just mention here is there's a lot of money on the table, and so the fighting's going to be furious over who wins. There's it's an extremely large, no pun intended, patient population. We're talking about diabetes, obesity, weight loss, and all sorts of new indications, obsessive compulsive disorder, all sorts of new indications that are down the road. And so the manufacturers are, filing lawsuits to protect patients from these products. And for prescribers, we advise that, never include any reference to a brand product, never state the compound as a generic version. Document any kind of clinical difference. Make sure you have that in the patient's chart. Always ensure that the potency and sterility to avoid adulteration and misbranding claims, that's on the pharmacy. That's not up to the prescribers, that's the pharmacy. API vetting, that's also the 503A pharmacy. They have a duty to make sure that the product has the appropriate certificates of analysis and all that. Regularly or in inordinate amounts, that only comes into play when it's essentially a copy. So that's, again, up to the pharmacy. Medical necessity we spoke about. And as far as the patents, we haven't seen patent litigation because it's been on shortage. That's not to say in the future that the manufacturers might not try to go that route. They haven't yet. But, when something is compounded, basically, in most countries in the world, if it's being compounded, it's exempt from patent infringement. The United States patent law is a little bit different, but again, we haven't seen the patent infringement cases. Next slide, please. So Arielle's covered all this, the partnerships with the ordering physicians. There is a Lilly Direct and a Novo Nordisk program. And basically it has, they're starting to look at vials and things like that. It's important, as Arielle mentioned, to know the regulatory risks, the federal and the state anti-kickback statutes, the Stark Law, Board of Pharmacy issues, Board of Medicine issues, and be aware of what's going on. Keep your fingers on the pulse of what's going on with these compounds, because it changes very, very rapidly. We may see something for that OFA case tomorrow. We never know. And with that, if there's any questions.
Martha, one question that a lot of folks seem to have, especially prescribers, is if a prescriber is ordering their supply from a 503B outsourcing facility and it has been ordered and purchased during the grace period, can that provider continue to dispense or administer, but primarily dispense that product after the end of the grace period? And does it matter whether it's a physician office that's ordered that product, or if it's a 503A compounding pharmacy that ordered that product from a 503B? Can they keep dispensing if it was produced at a time that it was permissible to be compounded?
So for the physician practices, you're in a more defensible position because the FDA says compounding, dispensing, and distribution. And the distribution piece is mostly pertains to wholesalers. It could pertain to 503B to physicians, but it's really a stretch. So I would say that for the physicians, if you have the product, you can continue to just have your patients receive their prescriptions that that have been dispensed to them from the 503A. The 503A pharmacy, it's a little bit grayer, but if past practice is followed here, and if FDA had not put the wording into their clarification on their website, there's nothing in any rules that say that if you have product inventory, you have to destroy it. And so this is uncharted, territory. It would not make sense. It would, it would just be such a waste to have product be destroyed that's already compounded. It's legitimate product. It's not adulterated. It's not branded. So, and it's a limited period of time here we're talking about, right? The expiration date of this product that was purchased during this period of time and everything. So I think it's in a defensible position for both the 503A, but definitely, for the physician practices as well.
Thank you, Martha, and thank you everybody for joining us. Our contact information is up on the screen, and if you'd like to connect or you have any additional questions, we are happy to hear from you.